Good morning, everyone, and welcome to the fourth in our series of webinars hosted by the Fieldfisher Silicon Valley office. We'll be starting in just a couple of moments. Good morning, everyone. Welcome to the fourth in our series of Fieldfisher webinars. Each month we've been looking at practical issues arising from discrete points under GDPR. We've tackled data subject rights and controller-to-controller arrangements in the recent months, and this time we're covering the most headline-hitting aspect of data privacy at the moment, and that's personal data breaches. We're going to look at how to prepare for, investigate, and respond to a dreaded breach. As always, we've put listeners on mute throughout the webinar, but feel free to ask us any questions using the comment box. And if we don't get a chance to cover them during the webinar, we'll answer them when we circulate the slides afterwards. You may have noticed it's a new voice welcoming you this morning. I'm Megan Ward, and I'm a trainee solicitor in the privacy team out here in Silicon Valley. I've been over here for just nearly 3 months now, and very much enjoying my time in the Bay Area so far. I'm joined today by 3 of my brilliant colleagues who all specialise in handling data security incidents. First up, Felicity Fisher. Flick's a director in our team who specialises in European privacy and digital regulation. Flick's an English qualified solicitor, has been practising law out here in the Bay Area for 5 years now. Next up, we've got Alden Takitimu. Alden's a senior associate in the Fieldfisher team, specialising in privacy and information security. Alden is a New Zealand qualified solicitor and barrister, but spent most of his career practicing in the UK and moved over from Fieldfisher's London office earlier this year. We're also joined today by Paul Lamois. Paul has recently joined the Fieldfisher team as a director and specialising in global privacy, data protection and information security. Paul is both French qualified and a member of the state bars of the District of Columbia and New York.
He also has every IAPP qualification there is.
Well done, Paul.
Before joining Fieldfisher, Paul worked in-house and has practiced law in Hong Kong and Switzerland. Is that correct, Paul? Yeah. So today, as I've said, we'll be focusing on handling data breaches under GDPR. Probably should just flag up that there are, of course, other regimes that organisations need to be aware of if they suffer a personal data breach, for example, the EU's Network and Information Security Directive. But as we only have 45 minutes today, we're going to stick with obligations under GDPR.
But watch this space, we might do a future webinar on those data breach regimes.
Yeah, that could be the next topic coming up. So data breaches have inevitably attracted media attention and are a high enforcement priority for the regulators. However, the fines that have been levied in recent months due to the timing of the incidents have been capped at the level available under previous legislation. But as we're all aware, the fines are significantly higher under GDPR. Also, just last month, the UK courts, for example, have ruled on their first employee class action for data breaches, in which supermarket chain Morrison's was found liable for a data breach carried out by an employee 4 years ago. And so this demonstrates that the potential cost to organisations of ensuring compliance and also increases liability exposure. For breaches that have occurred after the 25th of May, we're yet to see any fines issued so far, although we know that investigations are underway. It has been reported that since the 25th of May, regulators have received around 18,000 data breach notifications. That's around 160 per day. But as we've said, whilst investigations are underway, we're yet to see the implication of the GDPR fines. So to kick us off with our questions, we're going first to Alden. So Alden, what should lawyers do in the first 24 hours when the call comes in that a security incident may have occurred?
Thanks, Megan. Morning, everybody. Well, the number one thing I believe that the lawyer's role in the first 24 hours when breaches happen is to not panic and not add to the chaos which is inevitably occurring in your organization. Now, I'm not saying that in some organizations breaches don't happen and you follow your pre-prepared breach preparedness plans and incident plans to the letter of the law, but the vast majority of the breaches I've worked on, usually people are running around like headless chickens. They're trying to establish the facts. Now, as the lawyer, you can't be one of those headless chickens, and you can't add to the chaos, particularly because your organization is going to be looking to you to sort of keep calm and establish, give them some legal guidance on that important first 24 hours, but without interfering with what the IT teams need to do and what the various other teams need to do who'll be involved in the process. The second thing you need to do is you need to establish what process you are following. Is there a breach response plan or an incident response plan in your organization? Often there is one, but sometimes they're not used, as I said, in breaches. Sometimes the business doesn't know that they exist. So sometimes your first job as a lawyer is to let people know that there is actually a process or a procedure in place. If there is a procedure, is there a CERT or a security incident response team that needs to be convened? If there is no such process, get the people in the room, work out what needs to happen, and really focus on what your job as a lawyer or the DPO or the compliance person is. As I alluded to before, your job is to guide the process. It's to do the legals or the DP work on the process. It's not to tell the security teams or the IT teams what they need to do. So, some of those tasks might be, do you need to engage a forensics provider? If you don't have one on retainer, someone's going to need to put an engagement letter in place. Somebody's going to need to put NDAs in place. And my colleague's going to talk a little bit more about that afterwards. The third thing you need to do is you need to establish the facts. It sounds really simple, but you've really got to understand in that first 24 hours who knows what. When did the incident happen? Is it still occurring? What containment steps have you put in place? And then start to think about what your job is in the process and what you need to do your job. So what type of breach has happened? Are you dealing with something which is a hacker or an external threat? What sensitivity of data? What volume of data are we talking about? What countries? What jurisdictions? All of those sort of things, and start to document what's going on. So many breaches that we work on, it's such an important step, just getting into one place, whether it's an email or whether it's a file note that never leaves your desk. Just getting an understanding in that first 24 hours about who knows what, because often you've got various different conversations going on, various different email chains, whatever. I think that the lawyer's job has to be to bring that sort of factual matrix together into one place.
Yeah, and it's split here, and I'd also just add that having been on the end of a number of incidents where, as outside counsel, it's Friday afternoon and you're really looking forward to your weekend, and suddenly you get the call that there has been an incident, and actually what's happened is that the organisation has usually sat on it for a few days trying to gather the facts and pull together the information. But actually, if you can get outside counsel involved within the first 24 hours, I think that's a really useful, or at least once you've got the initial facts in place, because they can help guide the process as well. And kind of leaving it till Friday afternoon means we're always in a frantic scramble to do things like deal with notifications when the regulators are going to shut up shop for the weekend. The other thing I would say is that in the first 24 hours, it's really important to start to manage the internal communication process. And we will talk a bit about that in future slides, but things like, it's an absolutely obvious one, but still people trip up on this. Do not call it a breach until you know that it is definitely a breach. So you need to make sure that those internal emails that are flying around, raising the red flag, don't mention that it's a breach, and start calling it an incident until we're absolutely sure that we're dealing with a breach.
Yeah, we were involved in a breach recently where by the time we got engaged, I think about 60% of this particular company's workforce had been copied into a mail which is entitled "OMG, we have a breach."
Yeah.
Avoid that.
That actually leads us nicely on to the next question, which is for Flick. We know that all personal data breaches are security incidents, but not all security incidents are data breaches. So when does an incident become a breach?
Yeah, so thanks, Megan. So, well, we've got the definition of personal data breach in Article 4 in the GDPR, and it basically means a breach of security leading to accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data. And the crucial thing here is that it needs to involve personal data, so that's the first thing. And the second thing is that it includes breaches that are the result of both accidental and deliberate causes. So, as Megan said, not all incidents are breaches, but in most cases, if they involve personal data and you've got any kind of unlawful destruction, loss, etc., that falls within that definition, you've definitely got a breach. Now, the definition is actually extremely broad when you start to break it down. So it can basically be defined widely as a security incident that has affected the confidentiality, integrity, or availability of personal data. So that in practice means there will be a personal data breach whenever personal data has been lost, destroyed, corrupted, or disclosed, or if someone accesses the data or passes it on without proper authorization. It can also include a scenario where data has been made unavailable, i.e., and the example that the regulators often provide is that it's been encrypted by ransomware or accidentally lost or destroyed. And that the idea that the data is unavailable can also include temporary unavailability, unless that temporary unavailability was due to some kind of planned maintenance or downtime. And so recital 87 of the GDPR is quite clear that when a security incident takes place, you've got to quickly establish whether a personal data breach has occurred, and then promptly take steps to try and address it. And I'm going to talk a little bit next about when the clock starts running in terms of notifications.
Hi, this is Paul speaking, and just to add on to what you just said, I think what you mentioned is really crucial. Data breach is not only what people commonly think about data breach. We lost access. An unauthorized person had access to the information. Data breach is actually much broader in the GDPR, right? Because as you mentioned, if you have lost if the data was lost, if it was destroyed, altered, and so forth, then there would be data breach. And this means that it's not so much an issue of data leakage. It's also a question of, do you have a backup of the information? Are you able to recover the information very quickly? Because if you don't have any good quality backups, if you don't have a process in place to quickly restore the data to be back up to speed, then this means that you have a data incident which may need to be reported, even though there was no data stolen, even though the data was just destroyed.
Yeah, and I think that's it. Another important thing is that the actual definition of personal data, of a personal data breach or a data breach, doesn't whether or not it falls within that definition doesn't require an initial risk assessment. So if you've got something that data's been lost, stolen, or there's been an issue with availability of the data, at that point you've got a breach. And the second assessment would then be, okay, so we've got a breach, and then you start to do your risk analysis to determine whether or not you may need to subsequently, because of that breach, notify individuals or regulators.
Thanks, Vic. So next question also for you. As you mentioned, who do we need to notify and when?
Your notification obligations will vary depending on whether you're acting as a controller or processor in relation to the affected data. So if you are acting as a controller of the data, you've got two notification obligations to be aware of. Your first notification obligation will be to notify the regulators without undue delay and latest within 72 hours of becoming aware of the incident if that incident is likely to result in risk to the affected individual's rights and freedoms. And then the second, and I'll go into a little bit more detail about what that means in practice, the second notification obligation to consider is your potential obligation to notify the affected individuals. And there's a slightly higher risk threshold for that. So unlike the scenario where you have to notify the regulators if there's any risk to the individuals, the bar is slightly higher for notification to the affected individuals. So that would only apply if there's a high risk to the rights and freedoms of the individuals, and in that case you've got to notify them without undue delay, i.e. as soon as reasonably possible. So going back to the first notification obligation, so you wouldn't need to notify the regulators if it's unlikely to result in risks and any kind of risk to the underlying individuals. And so there is an initial risk assessment that needs to be done, and we'll talk a little bit more about that shortly. But the Article 29 Working Party has issued some guidelines on what to consider when it comes to breach notification obligations. So worth checking those out because it goes into some significant detail. But it basically provides a couple of scenarios where the risk may be low enough not to trigger notification obligations. And it includes scenarios like the data is publicly available, the data is being encrypted or securely hashed or salted, and the key remains confidential and can't be accessed. There's some kind of temporary loss of access, but you've been able to restore it. Or if it's been accidentally sent to a third party, but that recipient is actually a trusted third party, like your lawyers or someone like that, that wouldn't necessarily create any risk in that scenario. But then in any event, whether or not you decide to notify or not, you should always be documenting the decisions that you're making and the rationale for those decisions. The other point to flag here is that notification can be done in phases. So if you haven't necessarily got all the information and all your house in order yet, but the clock is ticking and you're getting to the end of the 72-hour period, you should definitely get in and start to notify the regulators and let them know that you need a little bit more time to complete your initial investigation. And then, you can follow up and should follow up without undue delay as and when the information becomes available. Just because you haven't got everything you need, don't sit on that notification. You should do it because you've got the ability to do it in phases. And then in terms of who you should notify, this often is something I really recommend that as an organisation you figure out who your regulator is and who you need to be notifying, because there is quite a legal assessment to potentially do to determine, for example, if you're able to identify a lead supervisory authority, and there's a whole legal analysis behind that. But if you have identified the lead supervisory authority, then you should be notifying them. Or if you're based outside of Europe and you've appointed an EU representative, the guidance from the regulators suggests you should notify in the country where your EU representative is based. Or alternatively, you may have to notify all of the affected member states where all of the affected data subjects are. But if in doubt, the guidance suggests that you should notify where the breach actually takes place. When it comes to notifying the data subjects, you've got to do that without undue delay, i.e. as soon as you can. And there are a couple of exemptions to that notification requirement. So if, for example, the data has been rendered unintelligible because you've got state-of-the-art encryption, tokenization applied to that data, or it's been, pseudonymized, you may be able to get out, or it may be sufficiently lower risk at that point because it's unintelligible. Or if following the incident you've taken enough steps to kind of negate some of that risk, and you've taken a number of mitigation steps so as to lower the potential risk to the individuals, so it's no longer high risk. At that point, you wouldn't necessarily have to notify the data subject. So that really emphasizes the importance in that first, 24 hours, 48 hours, really getting stuck into taking steps to mitigate the risk to the individuals and addressing containment, because it can actually mean you don't end up having to notify the individuals. Or if notification would involve disproportionate effort. And I think that's going to be very narrowly construed. So that might apply, for example, if you don't have the contact details for all of the individuals who've been affected. But nonetheless, you would still be expected to make some kind of public communication or notify by similar means. And then the other really key point here is that the clock starts ticking on all of this, so for the 72-hour period, once you've become aware of the breach. And the guidance suggests that awareness kicks in, and you will be aware of a breach once you have a sufficient degree of certainty that an incident has taken place. So in practice, that means you've got a short period to sort of address and investigate the facts to figure out whether the incident is in fact a breach. And a lot of people play around with that time period and use that period of investigation and until you become aware to kind of extend your time frame and give you a little bit more leverage to investigate and not be rushing around. So if you notice 72 hours kicks in as soon as you become aware, so you've got a bit of time there to just figure out whether or not you've got an incident, but you haven't got days, you've got to do it pretty quickly. The other thing to be aware of is that 72-hour time frame includes weekends. So just because the regulators have shut up shop, you've still got a notification obligation if that 72 hours ends over a weekend period when, for example, their hotlines may be closed, which they are. So turning to if you're a processor, your obligation is slightly different. So if you are a processor, the bulk of your notification obligations will be addressed in your contract with the controller. And you are contractually required to agree that you will inform the controller without undue delay. So again, as soon as possible. But notice there's no risk threshold for a processor notification. So in many ways, if you're a processor, your notification obligations are much broader because you're not making that initial assessment of whether there's any risk or there's a high risk to the individuals. As soon as you've got a breach, you've got to notify the controller, and you should also be checking what your contract says because you may have committed to certain timeframes, even though legally you're only required to agree that it will be without undue delay.
Thanks, Vic. So as you said, the risk threshold for notifying individuals and regulators is different. So how do we assess the risk?
Yeah, so again, there's no exact science to this, and people get a bit nervous around doing this risk assessment because they don't want to get it wrong. But there is it's supposed to be an objective assessment, but there's no kind of firm criteria. Sometimes you see those yes, no, and you end up at, high risk or low risk. There's none of that to help us here. We do have to turn to the guidance and see what the regulators sort of think we should be factoring into this risk assessment. But you've basically got to consider all the possible consequences of the breach and both the likelihood and severity of the impact to the individuals. And that, when you're looking at the impact to the individuals, that can be extremely broad. So it covers both physical, material, or non-material damage. So it could also include things like whether or not the individual is likely to suffer significant economic or social disadvantage, loss of control over their personal data, a limitation of their rights, and that wouldn't just be privacy rights. Any kind of discrimination or identity theft or fraud, financial loss, all of that kind of stuff, damage to reputation, that should be factored in to considering the impact on the individuals. And now, unlike when you do a DPIA and you need to think through the risks that that may be suffered for, or the risk of harm to the individuals, a DPIA kind of focuses on the likelihood of harm in a breach scenario. But in an actual breach scenario, the focus should be on the resulting risk of the impact of the breach. That's a slightly different focus. So really, we're being asked to consider the specific circumstances of the breach. And there are a long list of things that the regulators sort of say that we should all be looking into. And, you've got to look at the type of breach, the nature, sensitivity, and volume of personal data. So the more sensitive the data, the higher the risk and likelihood of harm to the individual. So if you've got things like health data, identity documents, or financial data, that is probably going to be or likely to result in a higher risk of harm to the individuals. Or if you've got a large volume of data subjects, that would be another higher risk scenario. Or you've also got to look at the ease of identification of the individuals. So if the data's been effectively pseudonymized, then it may, present a lower risk than if it's in a, straightforward identifiable form. The severity of the consequences, who is it being sent to? If there's been an unauthorized disclosure, if it's a trusted recipient, again, it may be lower risk. Look at the special characteristics of the individual, they children or vulnerable adults. And again, the number of affected individuals. Those are all the things that you need to be building into your risk assessment. And you should be documenting that risk assessment and showing that you've thought through the issues and are able to prove, how you've come to your assessment of risk.
Thanks, Flick. So next question for Paul. We know that there's obligations to notify regulators and individuals, but may need to consider notifying third parties, for example, law enforcement. So when do we need to reach out?
Thank you very much. My proposal is actually, not to wait for a data breach, to actually happen, to actually start finding out, who you should contact within law enforcement. My proposal is actually to try to engage law enforcement before a cybersecurity incident happens, because it's always very good to have a point of contact and to build a pre-existing relationship with someone working within law enforcement, so that whenever an incident happens, you actually have a point of contact. You can actually just reach out to the person, and this will facilitate any future interaction that you will have with law enforcement. And it's always good to build this trusted relationship. When a data breach happens, most of the time, like Eldon mentioned earlier, everybody's panicking. You have 72 hours. It's not necessarily a good idea to wait for that 72 hours to happen to then say, oh, well, who do I reach out within law enforcement, and to just call the hotline? That's going to take time. You have to do some research and so forth, and they may pass you from one desk to another, and it's you have very little time. 72 hours is very quick, so you should not wait to engage with them. And then when the incident takes place, the starting point should always be to first examine within your organization, especially if you are working in a large organization, examine which law enforcement agencies are really in contact with your organization. Maybe especially if you are working in a large organization, maybe the data breach has already been it has already appeared, in the media. Maybe there has been someone who's already blackmailing you on Twitter or on social media, and it's always good to check whether someone has already contacted you, because you want to be, as an organization, you want to be speaking in a single voice. You don't want to to have multiple people contacting and reaching out to law enforcement, and maybe the information may not necessarily be the same, and it's always an issue if you cannot get your house in order. So always start by checking whether your organization has already been contacted by law enforcement, and then you should also take into account existing relationships as well, as I mentioned earlier, and then the market practice. Maybe in one specific jurisdiction, maybe there is an expectation that you are supposed to reach out to the law enforcement within immediately, and in that case you have to do that. And then in relation to existing relationships, sometimes the organization may already be speaking with law enforcement in relation to another incident or whatever, and it's always very bad, if you don't tell the law enforcement, with whom you're already speaking with, that there is a new incident or whatever. So that's why, it's always important to check, are you already in contact with law enforcement? And, in that case, well, you need to leverage them. And, in many cases, it's prudent to engage with Europol, the FBI, local law enforcement authorities. It's very good to be able to leverage the expertise in evidence gathering, and many times they have dedicated teams. They have lots of contacts within the industry and so forth, and then they would be able to help you as well. Maybe they are aware of a specific threat which is targeting a specific industry. Maybe they are aware, for example, in relation to ransomware. Maybe they are already aware of this type of ransomware attack, and they would be able to help you to unlock your computer. It's always a good idea as well, to engage with them, because they can help you as well to make sure that the evidence can be used in future court proceedings and investigations. Having said that, it's always important to bear in mind that many times you have investigations which would begin in one country, and especially if you're working in a large international organization, you would have an investigation which would start in one country, and then it would just cross over to another jurisdiction. And that's why it's always important to consider as well all the jurisdictions which may be impacted, and and when you reach out to law enforcement, you don't just reach out to the law enforcement in one specific country. You may have to do it for a whole range of different countries, because you operate in those countries, and the data breach may have an impact in those countries.
Thank you, Paul. So moving on to communications during the incident even, how do we maintain privilege?
Legal privilege is a very important topic, and you should always keep it at the heart of your incident response strategy, because whenever you have discussions between the attorneys and the clients, within the context of providing legal advice, that is confidential communication, which may be protected, and you may not necessarily want those communications to be used and to be brought up in the context of upcoming litigation which may appear. And therefore it's always very important to make sure that you protect attorney-client privilege wherever it exists. The protection it varies in scope and in application depending on the country. It's not a universal protection. So some countries recognize attorney-client privilege, others do not. And therefore, again, if you operate in many countries, it's important for you to map out and to understand the context, the scope of legal privilege in the different countries. And so that will be the first point, understanding the legal privilege law in a different country. And then I would say the first step would be, in order to maintain privilege, you want to retain outside counsel right from the start. Whenever you believe that whenever you're aware, of an incident taking place, it's good to retain outside counsel early and to keep them involved in discussions. You want to maintain privilege. Many times you don't know at the beginning whether it's a real data breach, maybe just an incident, with no further bearing, but then engaging external counsel, right from the start helps you to maintain the privilege in case the incident turns out to be a data breach. In order to maintain privilege, you should have external counsel, responsible for providing the legal advice. They should be the ones retaining forensic cybersecurity experts and to direct response actions to protect the investigation and internal communications. One important point as well, is to make sure that when you are getting advice in the context of an incident, you should not assign legal functions to outside vendors who are not attorneys, unless their function is outside of your general area of expertise, and you need their advice in order for you to render your legal advice. The reason for that is that nowadays you have lots of consultants, especially after the GDPR, you have lots of consultants who are providing advice in relation to data security, GDPR advice, and so forth. And while what they may do, maybe interesting, the problem that you have here is that their advice will not be protected under the attorney-client privilege, and it may therefore be used against you in the context of litigation. Another important tip is, whenever you have an incident, you should separate the incident response team from the team conducting the investigation to aid the legal department. So this is actually, what happened in the Target case. So you had this data breach at Target. Target being, a very large chain of supermarkets here in the United States. And what Target did was that they retained outside counsel, and then they had a team which was in charge only of providing privileged advice to aid the legal departments. And as often in the United States, you had a class action. You had a number of plaintiffs who were saying, well, they want to have access to the information provided by the legal team. And what happened here was that the plaintiffs were arguing, well, investigating a data breach, that's the ordinary course of business. You have to fix the incident. You have to you have to help the customers who are the victims of the breach and so forth. And therefore, this is something which does not fall under legal advice. However, the courts here say that, well, actually, because there was a separation between the two teams, you had an incident response team which was providing investigation. They were trying to determine what happened, how to fix it, and so forth. And then in parallel, you had a separate team which was in charge of providing legal advice. That separate team engaged forensic experts and so forth. And in that context, it was possible to protect the confidentiality of the communication. So always make sure that you separate the two teams.
Thank you, Paul. So from a broader communications perspective, Eldon, what should organisations be thinking about when devising communication strategy?
Thanks, Megan. Well, my colleagues have sort of stolen my thunder on the first 2 points, but I will, so I'll keep it as brief as possible. And
Sorry.
My excellent colleagues. So in terms of the internal messaging, as we mentioned right at the outset, don't call it a breach. Don't have myriads of emails talking about breaches, and for all the reasons that Paul's just talked about, all of that stuff might be discoverable. So from your internal comms perspective, establish early on what the means via which you're going to communicate, and then once you're past that investigation stage, also consider how you're going to message the fact of the breach happening to staff. It could be that staff are affected as individuals, but also from a general perspective, how are you going to message staff? How are we going to involve HR in that process, or anybody else internally? In terms of the external messaging, Flick's going to talk about, or one of my excellent colleagues is going to talk about the contents of the notification on the next page. So I won't talk about that in terms of the regulatory notification obligations, but you want to be thinking about how best you can send that external message if you need to. Now, we already mentioned earlier that you may not be able to contact individuals directly. You might have their contact details, so you need to think about whether it's via one of your platforms or a website, how you're going to notify individuals of that breach, and then obviously anybody else outside of the organisation. I don't know if we've brought up I don't think we've mentioned the dreaded insurers, but they are an external party alongside law enforcement, etc., who may well need to be kept abreast. Now, and if you are acting as a processor, now, I know that we talked about this briefly, and in one sense, taking a pure GDPR view, as a processor, you don't have a risk assessment to make. If you determine that a personal data breach has happened, you need to notify your controller customers. So in preparation for doing that, you need to have a clear idea of who those customers are and how to contact them. I think a really important decision to make is that whether those communications with those controller customers are going to be business led or legal led conversations. And I think you can. There's no right or wrong answer in that, but certainly you need to involve the business in that decision making. Make sure that account leads, and don't be afraid. This might be stating the obvious, but don't be afraid to treat your important customers with a different comms plan to your less important customers. I'm getting the hurry up. So I will move on to Paul, I believe, who's going to tell you about what's involved in the notification.
Yeah, we've only got a couple of minutes left, but if you're okay to bear with us, that would be great. So Paul, over to you.
Thank you very much. I'm going to be very brief because we're running out of time. So what's involved in a notification? Well, many DPAs, they have established online notification forms, and you'll notice that unfortunately the forms are quite different depending on the country. So even though you have the GDPR, which applies across the European Union, well, in relation to the notification forms, the forms are actually quite different depending on the country that you need to make the report to. You have only 72 hours, remember, to conduct the investigation. And many times when you have a breach, the breach would be quite complex, and 72 hours may not necessarily be sufficient, for you to conduct an in-depth investigation into what happened. Most of the time, such investigations take much longer, and because you only have 72 hours to make the notification, and what you need to do is that you need to, in that case, make an incomplete report to the authorities within a 72-hour window. And then when you have more information, then you would provide such information to the authorities when such information becomes available. In relation to the type of information that you must provide, these are set out in the slides as well. The contact details for the DPO, the categories and the number of affected individuals, the types of records concerned, the description of the nature of the breach, the likely consequences of the breach, and the measures which have been taken or which are proposed to be taken by the organization following the breach.
And we'll just quickly add to that, but as Paul mentioned before, each of the forms is quite different. So you might be asked to provide additional information over and above that minimum information requirement. The other thing to flag is that most of the forms are online, and you can do it through downloading their form and submitting it to them. A couple of them, like the English regulators, have a hotline that you can call up, but it's only staffed between 9 to 5 UK time, and I believe that the French regulators have some kind of hotline, but it's only in English at some bizarre time on a Tuesday between 4 and 5 or something like that. So be aware that if you're notifying the different regimes, you've got to do it in the local language, and the Irish and the English regulators are the only ones you could probably do it in English on the form.
Thanks, Vic. So just one final question before we finish, which is an open question for everyone. I know we've mentioned that even if organisations don't notify, records should be kept. Is there anything else we should think about?
I think the common thread throughout all of this is make sure you've got your clear audit trail, which documents the steps you've taken and why you've made key decisions, like to notify or not to notify. The other big takeaway is, even if the breach is not reportable, so you don't have to notify it to the regulators or the individuals, you've got to document the facts, its effects, and the remedial action you've taken to comply with the GDPR requirements. And the final point there is just learn from your mistakes. So there should be a document and wash-up process afterwards, where you're thinking through with the appropriate stakeholders, what mistakes were made, and hopefully you can take steps to clean up your process.
Yeah, I'd echo that. There's nothing worse than getting busted with the same breach twice.
Yeah.
And having done nothing about it in between time.
And actually, what in between breaches, and I promise we'll finish very short, is it's really important to test your process, to maybe do some roundtable exercises. There is a brilliant site called, I think it's called @BadThingsDaily, and it gives you some examples of some security incidents that have been happening and what people have been doing about it. And that's quite a good resource to go and maybe come up with a test case to test the organisation. It's a bit like muscle memory. You just got to keep running through that policy and process to make sure it's efficient and slick, because when it does happen, a breach can be scary, and if you're trained well enough on how to deal with it, then it becomes a lot easier to manage.
And if you engage great external counsel.
Yeah.
Well, I think that's all we've got time for today, but thank you very much to my colleagues. Thank you very much to everyone that tuned in. As always, we'll make the slides available afterwards, and if there is any questions that have come through, we'll follow up with our responses to those as well. So thank you very much for tuning in, and enjoy the rest of your day.
Bye.
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 Cheers, Ron.